Hello, everyone, and welcome to the March 2024 episode of my PIP Monthly. As always, my name is Amber Rouse Holloway, and I'm an executive partner here at our Troy office. Today, I will be joined by an associate of our office, Joseph Giacalone, and Joseph will be presenting the trending topics in PIP litigation portion. But first up, as always, today we have a case law discussion section instead of a case law update, and I'll be touching on some prior cases from the Court of Appeals that I do believe deserve some much needed diving into. First up is the case of Paragani v. Edward Chidanecki, defended by Secret Wardle on appeal, and then we will move forward to the case of Wasick v. Auto Club. And again, Joe will talk about trending topics in PIP litigation, specifically discussing the state of assignments and PIP claims, what is an assignment, and how to defend against them properly. The assignments and PIP claims portion of today's broadcast will be kind of piggybacking on the February 2024 trending topics in PIP litigation as well. So if you guys are looking for some more information on the state of assignments, listening to that February 2024 trending topics section will also be helpful. First up in our case law discussion is the case of Paragani v. Edward Chidanecki. Again, defendant was represented by Secret Wardle on appeal, and ultimately here the court found that for a defendant to secure summary disposition, he must lay the documentary foundation necessary to uphold the assertions which he alleged entitled him to summary disposition. Now, the underlying facts on this case involve a motor vehicle collision with an unspecified off-road vehicle. Although the nuanced facts of precisely how the accident happened were disputed by the litigants, the facts of the accident can be distilled into ultimately two vehicles colliding as they both moved to the left near an intersection in a rural area of Michigan. Now, in moving for summary disposition, the defendant asserted that he saw the ORV pull out from a private drive in front of him and enter the middle of the roadway in front of him as well. As the defendant's vehicle grew closer to the ORV, he decided to enter the left lane to pass the ORV. However, as the two vehicles neared the intersection, the defendant alleged that the ORV initially appeared to veer right before swiftly taking a left-hand turn directly into the rear of defendant's vehicle, and that basically propelled the minor driver from the ORV. Now, in its motion, defendant asserted that he should be entitled to relief on the grounds that the ORV was illegally operated on the roadway, namely due to its operation by an individual under the age of 16, but there are some other issues. The lower court did agree and granted summary disposition. Now, overturning the ruling in the trial court, the Court of Appeals first evaluated the burden of proof necessary for a party to properly obtain summary disposition. Since the initial burden, as we all know, rests upon the moving party to support their claim by affidavits, depositions, admissions, or other documentary evidence, they cannot simply rest on mere allegations of fact to support their position or the basis of their motion. Now, in Paragani, the court noted that the defendant relied solely on two pieces of documentary evidence. One, a partial excerpt from the police report, and two, the local ordinance governing the usage of ORVs. The court ultimately found that both of these pieces of evidence failed to satisfy the initial burden of proof necessary to support summary disposition. Now, in regard to the police report, the court noted that police reports are generally considered inadmissible hearsay, but could be admissible in the context of a business document, or what's better known as a document prepared in the ordinary course of business. Now, here the court found that cited experts from the partial police report were insufficient to support a motion for summary disposition, as they did not contain any factual allegations or witness statements regarding the circumstances of the accident. The court further asserted that even if the entire police report were to be included in the record, it would still be insufficient, as the moving party failed to lay the proper foundational groundwork necessary for demonstrating the police report fell within the exception of the rule against hearsay, and therefore it is inadmissible. Now, the second and last piece of evidence relied upon the defendant in its motion for summary disposition in the trial court was the county ordinance governing the usage and operation of the ORVs in that respective county. The court likewise rejected the sufficiency of the reliance of the ordinance itself, noting that the moving party failed to attach anything further demonstrating that the ordinance was actually violated. The court suggested that the moving party could have produced an affidavit from the county official, opining that they had searched their records and determined that the minor plaintiff was not qualified to operate an ORV on the roadway, or even deposition testimony regarding the specifics of the minor's operation of the ORV, which could be used to determine compliance with the ordinance or non-compliance with the ordinance. In other words, the court found that the moving party's reliance on the ordinance itself, without something further demonstrating the factual sense of the ordinance that was actually violated, was insufficient to support the documentary burden required to uphold summary disposition. Now, the large takeaway from this case lies in the absolute necessity to properly lay the foundation for argument and not simply assert a position and leave the court to search for a foundation on its own. In the evidence-based court system that we are operating within, it's imperative that litigants properly brief their issues and lay the foundation for why the requested relief should be granted. Now, this issue specifically comes into play. Sometimes we have situations where we're arguing motions for summary disposition, and the court lets us know that they read our motions and ask us if we want to add anything further. We need to make sure that not only is the foundation laid in our briefs, but it's also laid on the record as well. Get that full argument in if you can, but during the discovery period, it's important to, every defense you have, get as much background information as you can and include that in that motion. Dive into these issues during the deposition testimony with the plaintiff. Like here, it simply would have been enough for the court if the plaintiff was specifically asked, how old are you? Are you aware of this ordinance? Should you have been driving? Were you properly licensed to drive this ORV vehicle? Are you aware of this ordinance? Read the ordinance into the deposition and then ask the plaintiff if they satisfied that. Obviously not, because at the time they were under 16, but just something other than this one document, what seems as if it would have satisfied the court. So again, it's important to lay that foundation and just not assume or not even allow the court to do an analysis such as what was done here. Just lay that proper foundation as deeply as possible. Now, moving on to the case of Wasick Auto Club Insurance. This is a soon-to-be published, if not published, opinion that was issued by the Michigan Court of Appeals. Now here, this case does heavily rely upon this Dufresne v. State Farm case, which I have cited in the slides for this episode, but ultimately here the court first noted the language of the policy primarily controlled the situation, since, as we all know, UM or UIM coverage is optional and not mandated by statute. Now, this case, this Wasick case, is the very first time the Michigan Court of Appeals defined the term hit and run vehicle. Here, it was not defined by either policy that was at play here. It's never been defined by the Court of Appeals, normally because a policy would define it, but here the Court of Appeals created their own definition based upon prior case law or case law from other states and based upon the common dictionary definition of the term. Now, just a brief background on this one. The plaintiff here was a passenger in a vehicle driven by his girlfriend. Their car was rear-ended by a Ford Explorer. Both drivers turned on their hazard lights, and the Explorer followed plaintiff's girlfriend's vehicle to the nearest parking lot. There, both drivers inspected their vehicles, ensured that there were no injuries. Plaintiff's girlfriend assured the driver of the Explorer that there was no damage to her car, and both drivers mutually agreed that there was no need to contact the police. They both left the scene without exchanging information. Now, soon after, the plaintiff was diagnosed with a concussion. He sought uninsured motorist benefits under both his policy and his girlfriend's auto policy. Both policies included UM coverage in situations where there was a hit-and-run vehicle and that hit-and-run vehicle's driver, owner, and operator were unknown, and also there had to have been direct physical contact with the vehicle plaintiff was occupying. So all of those had to be satisfied. Now, both carriers here moved for summary disposition on the basis that coverage was not available because the Explorer was not a hit-and-run vehicle under the common meaning of the phrase. They pointed to the fact that both drivers had stopped and talked to each other after the accident. Now here, as uninsured motorist coverage is optional, the court did attempt to look to the policy language, but it was not defined. So the court took it upon itself to define hit-and-run vehicle as a vehicle that hits another vehicle and the driver leaves the scene of the accident at any time before there is an opportunity to exchange information. Therefore, in situations where an insured is claiming uninsured motorist benefits on the theory that there was a hit and run, benefits could be potentially denied when the insured had the opportunity to get the other driver's information but allowed them to leave the scene, as we have here. Now I will hand over the trending topics and PIP litigation portion to Associate Joseph Giacalone. Again, Joseph will be talking about this topic in detail.
Hello everyone, again this is Joe Giacalone from Seacrest World's Troy office. Last month, My PIP Monthly discussed how MCL 500.3112 provides listed types of healthcare providers with a direct cause of action. Absent an assignment of rights, a healthcare provider cannot stand in the shoes of an insured, meaning that a healthcare provider cannot rely on the contractual rights of the insured, but instead has this direct cause of action. Now, before we get moving any further into a discussion about assignments and how they affect litigation, I think it first is important to understand what is an assignment. An assignment of a right is a manifestation of the assigner's intention to transfer it, by virtue of which the assigner's right to performance by the obligor is extinguished in whole or in part, and the assignee acquires the right to such performance. It's the Restatement Second of Contracts, Section 317(1). And as I learned in law school, generally, if there's a legal right to do something, it can be transferred via an assignment to someone else. In first-party PIP litigation, an assignment is almost always a transfer of rights to the first-party no-fault PIP benefits provided by a medical treatment provider in exchange for the underlying claimant's right to first-party no-fault benefits from their insurance carrier or from their insurer under the No-Fault Act. Now, an assignment is valid if it clearly reflects the intent of an assigner to presently transfer the thing to the assignee. Burkhart v. Bailey, 260 Mitch App, 636, 680 Northwestern 2nd, 453, from the Michigan Court of Appeals in 2004. Now, the court must determine whether an assignment in question purports to assign only past due and presently due benefits, or whether it purports to assign future benefits as well. Professional Rehabilitation Associates v. State Farm Mutual Automobile Insurance Company, 228 Mitch App 167, 577 Northwestern 2nd, 909, from the Michigan Court of Appeals in 1998. As a practice note, it's been held several times over by courts in Michigan that an assignment of first-party benefits for future treatment is not a valid assignment. And it has been well established that an assignee stands in the shoes of the assigner and acquires the same rights as the assigner possessed. First Bank of America v. Thompson, 217 Mitch App 581, 552 Northwestern 2nd, 516, the Michigan Court of Appeals in 1996. As a result of the No-Fault Act changes and the direct cause of action, often plaintiff medical treatment providers who have a cause of action under MCL 500.3157 are pleading the direct cause of action under MCL 500.3112 and an assignment of rights from the underlying claimant. However, not every medical treatment provider has a direct cause of action. Thus, the difference can be critical in cases like Andry, where the Michigan Supreme Court declined to hold that a medical treatment provider had the same rights to payment as the named insureds to a policy of insurance. Now, it can be certainly an issue in litigation where you have multiple parties that are claiming the same bills. So who has the right to collect? The underlying claimant or the medical treatment provider? Obviously, no insurer under the No-Fault Act wants to pay the same claim multiple times over, especially to multiple parties claiming the same bills. But under MCL 500.3112, payment by an insurer in good faith of personal protection insurance benefits to or for the extent of a person who it believes is entitled to the benefits discharges the insurer's liability to the extent of the payments unless the insurer has been notified in writing of the claim of some other person. meaning in practice it's really important to know whether a claim is being separately pursued by the medical treatment provider or as part of a claimant's main suit. When a medical treatment provider files its own cause of action, meaning its own lawsuit, it gets the cause of action. The statutory cause of action means as soon as it happens, the provider will represent the claim. And no assignment of rights is required for medical treatment providers that are listed within the No Fault Act under MCL 500.3112 and MCL 500.3157 for these treatment providers to sue directly. What about when it's a dispute over an assignment? Well, if a claimant's rights under the No Fault Act are assigned to a medical treatment provider, then the medical provider becomes the one who has the right for a given claim. Barclay v. Zarb, 300 Mitch Ave 455 at 483, 834 Northwestern 2nd 100 from the Michigan Court of Appeals in 2013. As a practice note, if the medical treatment provider files after the underlying claimant has filed his or her own lawsuit, then there are grounds for dispositive motions in the underlying claimant's lawsuit to dismiss all or part of the underlying claimant's medical expenses from their lawsuit because they're no longer the real party in interest. And to cover a couple important case law updates that have existed over the past couple of years with the interpretations of the Michigan Supreme Court and the Michigan Court of Appeals. Generally, a defendant insurer cannot challenge mutual revocations of assignments because the insurer is not a party to the revocations of assignment contracts between the medical treatment provider and the underlying claimant. Now, there's an exception when a third-party obligor makes a challenge that would render the assignment invalid or ineffective or void that's been recognized by Michigan courts that have been applying federal law. See David Christopher Perkins versus Suburban Mobility Authority for Regional Transportation, also known as SmartBus, an unpublished per curiam opinion of the Court of Appeals issued September 1st, 2022, docket number 357080 at page 2. Importantly, the relation back doctrine, which has been applied in other areas of contract law and in other areas of disputes, does not apply to the addition of new parties, meaning that if there is an assignment, a plaintiff medical treatment provider cannot rely on the underlying claimant's lawsuit where they've executed a separate assignment agreement. See Miller v. Chapman Contracting, 477 Mich 102, 105, 730 Northwestern 2nd, 462 from the Michigan Supreme Court in 2007, where a medical treatment provider has been dismissed from a lawsuit because the provider has executed an assignment and has not filed a separate lawsuit to represent bills. Then MCL 500.3145's one-year back provision may become an affirmative defense for an insurer. Further, a plaintiff cannot retroactively revocate an assignment of benefits agreement to circulate the one-year back provision of MCL 500.3145. One must be the real party in interest at the time the lawsuit is filed, and a retroactive or nunc pro tunc revocation may not be used to correct a factual problem that existed when a lawsuit was filed. See Robinson v. Satka and the ASU Group, Risk Management, and Suburban Mobility Authority for Regional Transportation, an unpublished per curiam opinion of the Court of Appeals issued April 6, 2023, docket number 359646 at page 7. If the underlying claimant has assigned away his or her rights to first-party no-fault benefits to a medical treatment provider prior to filing a lawsuit, then the underlying claimant is not a real party in interest at the time of filing their own lawsuit as to the benefits being litigated for the medical treatment provider in which the assignment exists. This leads to certain considerations that have to be factored in and understood when it comes to defending against assignments of rights. Has this been more than 1 year without the filing of a lawsuit by the medical treatment provider? Second, is there an explicit and unequivocal expression of finality required to constitute formal denials of claims that were submitted by a medical treatment provider? As we look to the Michigan Supreme Court's docket for the upcoming year, Encompass Healthcare PLC versus Citizens Insurance Company, Michigan Supreme Court docket number 165321 will be an interesting case to watch as to the effects on assignment law and how they interact with defenses that insurers under the No Fault Act will have. First, what constitutes a formal denial of the claim? Second, how will MCL 500.3145 affect the assignment litigation based on denial language as to when there was a denial? Oral arguments on this issue, as well as the Michigan Supreme Court's opinion, could greatly affect dispositive motions in cases where the underlying claimants execute assignment agreements to medical treatment providers, and defendant insurers are trying to seek that those claims are dismissed from the litigation. Thank you for taking the time to listen today.
And that is all we have for you guys today. As always, thank you for attending my PIP Monthly. Please feel free to contact me with any questions or comments. Thank you.